Your name. We can have a better possibility. You can just give us the resolutions. We can start from there.
May please, Your Honor, these are the appearances done to the Law Society elect, Senior Counsel Charles Kanjama, Senior Counsel Nelson Havi, Mr. Harun Dubi, Mr. Roger Sagana, Mr. Peter Wanyama, Honorable Babu Wino, Mr. Abner Mango,
Yes.
Mango, Mr.
I didn't get the other.
Did you get Mr. Honorable Babu Wino?
Yes, yes.
Okay. Mr. Abner Mango. Abner is A-B-N-E-R. Mr. Pius Oyo. Miss Wanjira Minor. Miss Connex. Connex is C-O-N-E-X. Mwaro. Mr. Mela Bwire. Mr. Willis Echesa. Mr. Paul Isaac. Miss Velma Maumo. Maumo is M-A-U-M-O. Mr. Timothy Okello. Mr. Nurdin Hagai, spelled K-H-A-G-A-I, and Dr. Duncan Okubas.
This matter under Section 87A of the CPC. Yes, we wish to make an application. You want to be
Could the charge be read out, or be given copies of the charge sheet? We don't know what is being withdrawn. I don't know if the court has got a copy.
That's fine, Your Honor.
Yeah.
There will be many Virginias and others. It is polite to give us a full name so that we know this is the prosecutor. If I say there was a Virginia here 10 years from today, when she's a judge, we wouldn't know which one.
draw all the charges against the intended accused persons. We have made a request to have the file reviewed further, and at this point we do not intend to proceed with the charges as they are. So now we would wish to make an application to have the charges withdrawn. That is all.
It is unfortunate that the prosecution would file a charge and then seek to withdraw it. That in itself is an abuse. This is a matter which is of public interest. And is tantamount to the weaponization of the criminal justice system. It cannot be that a charge is registered and before anything is said about that charge, the prosecution seeks to withdraw that charge. That in itself is an abuse of the process of the court. Your Honor, if you even look at the charge sheet, there's a way of withdrawing the charge sheet. I will not go to the charge sheet, but it just speaks to the point I'm making about abuse of the criminal justice system. And then, to make it worse, they say they want to withdraw the charge under Section 87A without giving reasons to persuade the court why it should be withdrawn under Section 87A. That means that the citizens, the free persons who are before you, as they leave this court, there's a charge filed or registered but withdrawn. But since it is withdrawn under Section 87, without explanation, as they walk out of this court, they don't walk out of this court as free citizens who have no charges hanging on their head. I thought that under our current present criminal justice system, looking at the Criminal Procedure Code, and if you look at the National Prosecutorial Policy, withdrawing of charges under Section 87A should be frowned upon. Is not a matter or a right which the prosecution should enjoy, of dragging people to court. And dragging lawyers to court, you know, the president of the Law Society is here from 9 o'clock. You should have been told that right at the first instance that these charges were going to be withdrawn anyway. There are other subjects who are being held out in the car. The charges have not been registered. But if I can borrow from the wisdom of Judge Madan, somebody who is under a criminal apprehension and is within the limits of the court, does not need to come to the court formally. As counsel, we can raise those issues here and say there's a Kenyan being held out there. He's not being told whether he can go home or go to his workplace. Only the investigating officer and the prosecutor can tell us. But since she's not telling us, Your Honor, you're the fountain of justice, and Mr. Victor Opio, who has been with us at the car park, should not be subjected to the oppressive treatment that is undergoing without the court coming to his aid. And the prosecutor knows that that's what is happening. We just shared, and she shared with us that that person is being processed. I don't know what the word process means. You know, it can mean somebody is being made into mincemeat. And since it's in a car, I don't know whether a 2-year thing can happen. You never know. I'm just saying these things. In Kenya, we live in you can never take these things for granted. So, yes, she can withdraw the charge, but not under Section 87A. There should be no charge hanging on the 3 persons before the court. They should walk out of this court with their heads high as free citizens. Your Honor, finally, I wish that the prosecution should be making up their mind. A criminal prosecution does not depend on how it ends, but how it starts. And it starts with an arrest, and for that matter, an investigation. So I'm inviting Your Honor to talk very loudly through your ruling about this manner of handling persons who are brought before the court or who are held by the police, so that we can really live by the values and principles of the Constitution. Article 19 of the Constitution says the Bill of Rights is an integral part of Kenya's democratic system. Bill of Rights. So whenever those rights are trampled upon, it is the entire democratic system which is established under the law and the Constitution which is being trampled upon. And finally, we would have just sat here and say it is okay, they have withdrawn the case. But these are matters which the court should talk about loudly and clearly.
Missions of my learned colleague, Senior Counsel Governor Orengo, would like to begin by asking the court to note the provisions of Article 49 of the Constitution on the rights of arrested persons, in particular Article 49F, 49(1)F. The arrested person has a right to be brought before a court as soon as reasonably possible. If the 24 hours ends outside ordinary court hours, the end of the next court day. So the arrested persons, the three of them, were entitled to be brought to court, as well as Mr. Victor Miseda, who was arrested together with the three persons that are before the court, and who is currently in the car park of the court. This is still within the jurisdiction of this court. It is within the court precincts, and he has not yet been brought to court. And Article 49(1)G says, at the first court appearance, to be charged or informed of the reason for the detention continuing, or to be released. And so we are in a very curious situation where the charges have been registered, but the prosecution has chosen to withdraw them even before the charges are read out, without explaining why they are being withdrawn, or whether there is an intention to charge the accused persons further. So what are the options open to the court on this occasion? Even as the application has been made under Section 87A, we agree that the court may proceed to release the accused persons who are before the court, and we so request. But the court may choose to move under Section 202 of the Criminal Procedure Code, which gives a subordinate court that has jurisdiction to hear and determine a case when the accused person appears in court or is brought before the court under arrest, if the complainant, having had notice of the time and place appointed for the hearing of the charge, does not appear or is not ready to proceed, the court shall thereupon acquit the accused, unless for some reason it thinks it proper to adjourn. the matter. So if no adequate reason is given for the withdrawal under Section 87A of the CPC, we hereby make an application to the court to acquit the accused persons under Section 202 of the Criminal Procedure Code. We have a further reason for saying so, Your Honor. In High Court case number E173 of 2025, Kenya Hospital Association, trading as Nairobi Hospital, versus the CEO, Kenya Hospital Association, and one other, in August 2025, Justice Sifuna issued order number 2 that pending the hearing and determination of the application, an interim order of injunction was issued restraining and forbidding the Directorate of Criminal Investigation, its director, as well as all the officers under his command, from summoning, threatening, questioning, detaining, or in any way interfering with the peace and liberty of any persons as are parties or witnesses in the suit on matters related to the leadership, management, and affairs of Kenya Hospital Association, also known as Nairobi Hospital. In flagrant disregard and contravention of these court orders and in act of open impunity, the DCI arrested and summoned the 3 persons who have been in custody, as well as Mr. Victor Miseda, who is also in custody in the car park of this court presence. So because of this flagrant violation of court orders, and because no substantive reason has been given why these charges are being withdrawn, we want to formally and strongly urge the court to enforce and safeguard the Constitution and the constitutional rights of the 3 accused persons, as well as Mr. Victor Miseda. We ask the court, 1, to order the prosecution to produce Mr. Victor Miseda before this court so that his situation may be handled together with that of the other 3 accused. Number 2, to order the release of the 3 accused plus Mr. Victor Miseda, as has been requested by the prosecution. We agree to that release. But number 3, that the release be under Section 202 of the Criminal Procedure Code and include an acquittal to stop the liberty of the accused being affected in future again, and to send a strong message that constitutional rights are going to be protected by the court. Finally, Your Honor, there is a 5th accused person called Ricardo Nyantika, who is an MCA, a member of a county assembly, who's also been arrested in relation to these charges and is currently at DCI offices along Kiambu Road. And we would request that he also be produced before the court before, maybe within the next 2 hours, so that similar orders can be made by the court regarding to him. Those are our simple requests, Your Honor. made on behalf of the three accused persons, Mr. Victor Miseda, who is within the court precincts, and that they be extended to Mr. Ricardo Nyantika. That is all.
Only to add and complement or supplement what they said, that Article 157, sub-Article 8 of the Constitution permits the prosecutor to discontinue a prosecution, but shall not do so without the permission of the court. I guess, Your Honor, the permission of the court must be granted on the basis of information and knowledge. It cannot be presumptuous. In this case, it appears the prosecutor gave herself permission and is informing the court, and therefore has not given any reason, not a single reason. She may have said a few words, but they were just words. If we had a graphic, something to count, we could only count them as words. 2, Article 157, sub-Article 11, directs the Director of Public Prosecutions in the performance of his duty or her duty, whatever it may be, to continue having regard, this is of Article 11, to have regard to the public interests of administration of justice, and the need to prevent and avoid, I would like to underline, prevent and avoid abuse of legal process. Again, I would like the court to underline abuse of legal process. It is important to note that the legal process is generally a conveyor belt, kind of the conversation we had earlier before we took the short break of 10 minutes. So you will say, oh, I have no file before me because the people are at the car park before me. That is a legal process. Now, the prosecution must take into account and ensure they don't abuse that process. 3, I invite Your Honor to look at Article 159, sub-Article 2, sub-sub D, which requires that justice, and again I underline justice, shall be administered without undue regard to procedural technicalities. So that the moment a complaint has been brought before the court by the prosecution or counsels or from the bar about a client, then the court needs to do justice, because that is what, if you look at the essence of the entire of Article 159 and 160 does. I want to conclude with 2 more points. If I invite the court to look at Section 3 of the Magistrates Courts Act, which requires that the judicial authority exercised by the Magistrates Court requires that the magistrate, the jurisdictional authority exercised by the magistrate court shall be guided by the principles specified in Articles 10, 159(2) and 232 of the Constitution. In sum, if I summarize that, this requires that human dignity, justice be the main object of the process of court. And Section 4 of the same Act requires that parties to a complaint before the magistrate's court shall assist the court to further the principal objectives of the Act, that is those articles I've mentioned. This deliberate and willful material and disclosure by the prosecutor, looking at the charge sheet, even though it has not been read to the court, the accused persons, there is much it doesn't say. It doesn't say which companies and where the reports were not made. It is dead on arrival. So this is clear evidence of abuse of they are failing to assist you to promote the principles of the Constitution. And therefore, that's why, my Lord, I ask that we say that all the law enforced immediately before the effective date continues in force and shall be construed modifications and exceptions necessary to bring it into conformity with this Constitution. Section 87A is not in conformity to it, and therefore it is not a section that we should attempt to quote next time. Thank you very much.
Okay, just one last thing. There was a gentleman by the name Gilbert Nyamoya who was also asked to appear with them this morning, and he is in court. But to our consternation, his name does not appear on the charge sheet, and he has been informed that he waits until other decisions be made as regards him. Our plea this morning is that whatever decision this court makes in respect of the three accused persons, that decision should also apply to Mr. Gilbert Nyamoya. That would be it.
One of the very last, if you may, there's serious violation of the Constitution in this matter. If I may start with Section 4 of the DPP Act, before I come to the Constitution, that the DPP should act in a manner that promotes public interest and confidence. Therefore, Your Honor, if the state is bringing a charge, then wants to withdraw the same charge, taking into account the manner in which our clients were arrested, then therefore, Your Honor, we need to change the DPP, because there is no work they are doing in that office except misuse of public resources. Your Honor, Article 25 of the Constitution talks about freedom from torture and cruel, inhuman or degrading treatment or punishment. This is a fundamental right, Your Honor, non-derogable right, a right that cannot be taken away from anyone. Together with Article 28, that every person has inherent dignity and the right to have that dignity respected and protected. Article 29F talks about a right not to be treated or punished in a cruel, inhuman, or degrading manner. Your Honor, the way our clients were mistreated, the way they were arrested, you would think, Your Honor, that we were in a movie. Things which are just experienced in a movie, Your Honor. In the presence of their family members, in the presence of the media, and therefore, Your Honor, this must come to a stop, only to be treated by the DPP with an infertile imagination that there is no charge. Charge has disappeared all of a sudden. Your Honor, you must stamp authority and give us a jurisprudential ruling that will stop all these behaviors. Lastly, Your Honor, I've looked at the Company Act 2015, and I've not seen anywhere where a company should have a patron. And a patron was heard going around this country saying that he has arrested, persecuted, punished, and convicted. Therefore, Your Honor, it is only in order for you to summon the patron to come and show us where a company should have a patron. Lastly, Your Honor, we have a client, Mr. Ricardo Nyantika, who was arrested on Saturday. He is a member of the County Assembly in my constituency, in Embakasi East constituency. He has a constitutional mandate to perform, to serve the great people of the Embakasi Ward. And up to now, Your Honor, is not being presented before this court. We'd like Mr. Nyantika to be brought before you, Your Honor. That's all.
To review cases at every stage. You're not, every stage of trial begins with plea. You're not, even at this stage, the DPP can still review. We've been informed, Your Honor, that my senior has not given any grounds, and Your Honor, the ground for review is sufficient to warrant the court to issue us with a writ. Also, Your Honor, you've been informed that we cannot approach you under Section 87. But at the stage where we are, Your Honor, that is the only provision under the procedural law, that is the CPC, that we can come before you. An invitation by councils for you to dismiss the matter under 202 will not be applicable. You know, this is not the hearing stage. Therefore, that provision cannot apply at this stage. You know, the invitation to dismiss can only come at this stage if councils are approaching you under Section 89, subsection 5, I believe, of the CPC as well. And that's not the case. You know, I see no ground that has been raised by the defense that would warrant you not to grant us leave. And I would invite the court to look at the charge sheet. I believe the names therein are Buckley Mugere, Magdalene Koki, and John Wayne. Now the court has been invited to consider two other persons. I may not have gotten all their names. That is Victor and Ricardo. And it's my people that it's not seized off. And also that should not be an issue to be determined by the court today. The court has also been invited, Your Honor, to exercise powers of habeas corpus for the production of these two people before you. Your Honor, that is a reserve of the High Court. And also, Your Honor, we've been told that, Your Honor, that we are misusing resources. The DPP is not, when it comes to review, it's not a misuse of resource. It's a necessity, Your Honor, to ensure that we are bringing files that, Your Honor, meets the threshold. So what the DPP is asking is for an opportunity to ensure that the rights, you know, any wrongs are corrected and every I is dotted, Your Honor. And lastly, we pray, Your Honor, not to be invited into the political arena. We've had the mention of a patron, Your Honor. I will not wish to speculate, but I pray, Your Honor, that the matter before you is concerning Barclay Mogere, Magdalene Koki, and John Yeo. And it's in the interest of justice, it's in the furtherance of administration of justice that, Your Honor, you allow our application and grant us leave to withdraw the charges. That's all.
Because I wanted to move on this ruling instantly. I may not have a. We have a copy of the ruling here with us, so that yes, I hear you. Because I proceed as your summary.
Yes, Your Honor, it was actually brought by them.
Proceed.
I started by saying it was brought up by my landed senior. And the decision, Your Honor, that I was presenting before you just before.
Your Honor, I think the challenge we have is that in rebuttal, it's meant to be sequential, so not to introduce new facts.
I have to make some agreement. Because you had already given me a ruling which I have here. I was expecting maybe they also have a rejoinder in front of the ruling. Then that will be balancing.
Yes, related to that matter.
Yes, it should have a relationship. So that's why I was asking when they are submitting whether they have a. Do you have a copy you will give me?
Yes, Your Honor, actually it does. Because what my landed senior was sharing is that order was stopping the summoning, but the JR.
This matter was coming up for plea today. The state, from the onset, made an application to have this matter withdrawn under Section 87 of the CPC. Counsels for the accused, led by Mr. Orengo and Mr. Kanjama, questioned what informed that decision. It was submitted on behalf of the accused that whereas the state can make an application to withdraw the matter, they must provide resources. It was also submitted that the accused have a right to be presented before court as soon as possible and within the timelines provided under the Constitution. The counsel also brought this to the attention of this court about other suspects currently not before this court. And there is one said to be within the court precinct, that is at the car park, and there is another one who is still in police custody. This court was urged that while making a determination on the issues raised in this matter, should also affect the rest who are not before court. Mr. Kanjama also rooted for withdrawal of the charges under Section 202 of the Criminal Procedure Code, and that the accused person should be acquitted. There was also submission that in the course of arrest, the suspect was subjected to degrading and inhuman treatment contrary to the dictates of the Constitution. In rejoinder, Ms. Kariuki for State submitted that the DPP have powers to review a matter at any stage. I have considered submissions made by the counsels representing the accused persons. It is a fact that the state have powers to make an application before this court to have a case withdrawn at any stage before final determination. That decision, however, to withdraw must be considered by this court and either allowed or disallowed. The law requires that the prosecution must give reasons for withdrawing, for making such withdrawal. The suspects in this case are yet to take plea. The court have not had the benefit of evaluating the evidence. It has been indicated that the decision to withdraw was on the basis of a review. In principle, the defense have no issues with the withdrawal. And Mr. Kanjama urged this court to make an application to withdraw this matter under Section 202 of the CPC. Looking at this section, it only applies where a matter was scheduled for hearing. The complainant who had notice to appear and testify failed to do so. On application, the state can then make an application to dismiss the charge and withdraw under section 202. It is not applicable in this scenario. The state has given reason why they are making this application for review. It's on the grounds of for withdrawal. It's on the ground of review. I would therefore allow the application to have this matter withdrawn under section 87 of the CPC. Some other issues also, but it's just as a reminder, and going by the dictates of the Constitution, the state, that is the prosecution, before arresting and prosecuting a accused person, must always ensure that they have evidence in their possession which can sustain their cases in court. There is another application which affects other suspects who are not before court today. And if there is a suspect who is within the court presence, then the charge sheet should be processed in the normal manner, and the process should be hastened. For the other suspect who is allegedly in custody, that case is not before this court now, and the court cannot issue directive in vacuum. The party affected have liberty to move court appropriately by filing any necessary application, which will be considered, and the court will give the appropriate directions. Lastly, the rest of the issues has to do with evidence, and there was the issue of Companies Act, and even at one point there was the issue of patron. The court is not seized of such facts at this stage and cannot make any conclusive finding. Those are the directions.
Also, like one of the foreign.
And in honor, the accused person
being asked by my friend Marshall DPP should ask Padron not comment about these matters in public practice. That's a very request.